It is time for today's Talkback segment. Each day we post a question on CourtTV's social media pages. We gather your comments and questions and respond right here on the show. Darrell Brooks will represent himself at his Christmas rampage trial starting next week during day 2 of a set of hearings to decide whether he would be allowed to represent himself. The judge accused Brooks of playing games. So we asked you, do you agree with the judge? Is he in fact playing games with the system? Still with me, criminal defense attorneys David Bruno and Francis Johnson. All right, guys, our first comment comes from Charlene. Charlene has a very simple statement. She says, he is exhausting. That judge is a saint. And Francis, I have to admit, I agree with her on both counts. It is exhausting watching this, and I continue to wonder if this had to be the outcome here. Now, we found out that when he did his pretrial examination, he does have a personality disorder. But that doesn't stop him from being competent to stand trial and competent to make this decision. Perhaps the judge could have stepped in. I don't know. What are your thoughts?
I tell you, I agree. Just exhausting, just tired from watching him. But the one thing that we can all agree is that the right to represent oneself is a basic right that was written in the first Judiciary Act, creating a judiciary in the government back in 1789. And so it is secured in the Constitution and the 6th Amendment. It doesn't mean it's a wise decision, but it is one that is a sacred right given the founders' rejection of the way defendants were treated in England. They wanted to secure that right. I will tell you, the court can appoint standby counsel and probably should. He's facing 6 counts of murder. And this is for his life, literally.
Francis, I will tell you this. In Wisconsin, they can't appoint them. So he had a public defender. Public defender's office will not act as standby counsel. If you want a standby attorney, you have to hire one on your own at your own expense. So that was an interesting thing I found out today during court. So that surprised me. All right, our next comment, guys, comes from Celeste. Celeste says, does he think representing himself means talking whenever he wants? If he doesn't understand, it's because he's not an attorney. He told the judge she didn't have a PhD. Well, he doesn't have a law degree. He got what he asked for. I think that's a fair assessment of the situation. He does have a high school degree. I think it was determined he is fairly intelligent, has average intelligence. Doesn't take much more than that to be an attorney, right, guys? But at the end of the day, David, your thoughts on this?
Yeah, well, there's an old adage. He who represents himself has a fool for a client.
I heard that somewhere.
And there's a reason because of that. Because even if you represent yourself, you have to abide by the rules of the court. And we have criminal rules of procedure. And more importantly, we have rules of evidence. So you can't just get up and say whatever you want. You have to follow the rules of evidence, meaning you have to ask open-ended questions on direct. You could lead on cross-examination, and you have to introduce evidence with foundations, authentications, and no hearsay rules. So that is why it is very difficult for anybody not being a lawyer, going through the training and understanding the rules of the court to represent themselves in the court. But guess what? I don't think it matters. I don't think it matters if he represents himself or he's got a lawyer. He's got Clarence Darrell himself. Yeah. This man is going down on these charges because it is gruesome. It's on video.
Yeah, and I think he's going down, and I think he knows it. I think he wants to go down his own way. That's the sense I get from this guy. Our next comment comes from Raven. I don't see why someone who wants to represent themselves be denied legal counsel and advice. That sounds like some kind of conspiracy by the judiciary to penalize or punish people who decide they want to represent themselves. She makes a fair point. And again, that goes back to what I mentioned to you earlier, Francis, that Wisconsin won't allow the public defender's office, according to the law, to provide standby counsel.
Well, I think that may be based on maybe not an old adage, but one that's got some wisdom to it. If you play silly games, you might win silly prizes. In Wisconsin, in this state, I think they're saying either we're in or we're out. We're not going to take this middle ground approach, which is a very difficult position to be in if you're standby counsel, certainly for a defendant like this.
I only have a couple of seconds, David. So do you think he's gaming the system here? Do you think he's acting more crazy than he really is as a way to sort of game the system somehow?
I think to your point, look, I think he will be found guilty. He wants to go down his own way. He wants to say what he wants. But it's just not going to happen like that. He's bound by the rules of the court. And he's going to figure that out relatively quickly, that's for sure.
Yes, he is. A couple of smackdowns from the judge, and he's going to learn very quickly. I suspect he'll be carried out the courtroom at least once or twice. All right, guys. David Bruno, Francis Johnson, thank you so much for being with me this evening. I truly appreciate it. Really enjoyed your input. Coming up next, folks, we're going to review the